Okay, so today we're going to look at the Bill of Rights with the First Amendment and specifically at freedom of religion. So let's get looking at this one. Now, when we talk about the Bill of Rights, of course, we're talking about the first 10 amendments, and the First Amendment is really broken down into 5 things. There's freedom of speech, freedom of religion, freedom of press, freedom of petition, and freedom of assembly. So it has more than just one thing there. So today we want to look at freedom of religion, and we want to look at it that it's broken down into 2 things. It's broken down between free exercise and establishment. So the free exercise means that your religion, if you want to eat special foods or wear special clothing or have special times where you pray, that's fine. You can do that as long as the practice does not infringe on the rights of others. The Establishment Clause is about the idea of the country establishing a religion. So this is going to be where we look at mandated prayer in school or compulsory church attendance. You cannot make people go to church. You cannot make people pray. This is going to be controversial, and we're going to look at some of those cases today and how this we're looking to build this wall of separation between religion and government. So here's a great crash course video that I linked in here for you to watch. I highly recommend you watch it. It's only about 6 minutes long. Well worth your time. So let's dig into some court cases. So the first one we want to look at is Everson versus the Board of Education of Ewing Township. Now notice this is 1947. So after World War II, the big question here for this court case is, did New Jersey violate the Establishment Clause in the First Amendment dealing with the freedom of religion? So let's look at the background. Everson was a taxpayer who challenged the right of a school board to reimburse transportation costs to parents whose children attended parochial schools. So this was a time where the school board decided that they were going to reimburse parents for transportation within the county, even if their kid went to a parochial school. Now, you should know that everyone who lives in a county is paying taxes, and that money goes to public schools. So if you choose to send your kid to a private school, that's fine. You're going to still pay your taxes to the public school, but you're also going to have to pay tuition for your kid to go to the parochial school. Everson was upset, and he did not believe that the parents who were sending their kids to private school should be able to get public tax money for transportation. So in this court case, the court ruled in favor of Ewing Township School Board, and they argued that this is a case where the First Amendment requires that states be neutral, and it is clearly neutral. It is not that only the parochial school parents are getting their money reimbursed. All the parents were, and that the parochial parents were still paying into the taxes. So this payment went to the parents, not the school. Therefore, it wasn't favoring the school or the religion, and it didn't just assist parents or the religion or the school. So that's our first big case, and this one wasn't quite so shocking. But as we're going to see as we move through, things become more tense. So in the McCollum versus Board of Education of Champaign County, this is a case that happened the next year in Illinois. Here we see the question is, did the use of public school system for religious classes violate the First Amendment's Establishment Clause or the Equal Protection Clause of the 14th Amendment? So what happened in this case? This is a case where the principle of release time, this idea that the school would set aside time every day for religious practice, and this included instruction. So the Champaign County Board of Education authorized a program in which outside religious teachers were hired by private third parties to provide weekly religious instruction in public schools. The classes were not mandatory. McCollum, who was an atheist, complained that her son was ostracized for not attending these classes. And McCollum eventually sued the school board in 1945, arguing that the religious instruction in the public schools violated the Establishment Clause. So I want you to think about it this way. So the school is allowing kids to leave class to go have a special religion class. This is happening during the school day. A private third party, the school is not paying for this instruction. The parents are allowing their children to go. They don't have to go. And so the school thinks at this point that this is okay because it's not the teachers doing it. It is voluntary and the parents are approving it. But the decision is that it violates the Establishment Clause. Here's why. You are using tax-supported property, meaning the school building itself, for religious instruction. And you're doing it in pretty close cooperation between the school authorities and the religious council. This is establishment of religion. So the pupils are required to attend school and were released part of their legal duty if they attended the religious classes. So the kids who didn't go to religion classes still, weren't released. So the winner here is McCollum. Schools are not allowed religion classes from outside groups to be taught at regular school buildings. So during the school day, you cannot have, let's say, Wildwood Baptist Church could not come in and have a class that they taught second hour every day because our building is funded by taxpayer dollars. They could not have a teacher teach that because the school is paying for the teacher, which is tax dollars. So this is a great reason why an organization like Fellowship of Christian Athletes meets at our school, but they meet before school hours. They are not allowed to meet during school hours. Also, the school is not allowed to pay a teacher to sponsor that group. It has to be done voluntarily. Now, this leads us into the Zorich versus Clausen case of 1952. Here we see another problem with religion classes. So the question is, did the New York program violate the Establishment Clause of the First Amendment? So here's the background, the facts. In the aftermath of the Supreme Court's decision of the McCollum versus Board of Education, New York City began a program in which public schools could dismiss students from classes. They would leave the school and go to religious instruction on, different grounds. Now, in the McCollum, the court disallowed the Illinois program because it was done during the school day in the school building. So the New York used a release time program, and this was upheld by the New York Court of Appeals. However, it's going to go to the Supreme Court. So the decision is that the court held that the release time program neither constituted establishment nor interfered with the free exercise. So the court noted that the public facilities were not being used for the purpose of religious instruction and that no student was forced to go. So Justice Douglas argued that there was no constitutional requirement which makes it necessary for government to be hostile to religions or to throw its weight against efforts to widen the effectiveness. So in summary, New York could allow this because it wasn't occurring in schools by staffs. The other thing is it is viewed as neutral. It was for all religions. If Jewish kids, Muslim kids, Christian kids wanted to leave school to go get further religious instruction, they could. That leads us to Engel versus Vitale. And I love this little image here. This is about a school deciding to have a non-denominational prayer at the start of the school day. So the constitutional question is does the reading of a non-denominational prayer at the start of the school day violate the Establishment Clause? So if you're wondering what is a non-denominational, that's like saying it's not a Catholic prayer or Baptist prayer or Lutheran prayer or Muslim or Jewish. It's just like we're going to say a prayer to God, very very neutral God, and we're just going to have this one religious moment in the day. So the facts is that the New York State Board of Regents authorized a short, voluntary prayer for recitation at the start of each school day. So somebody would get on the announcements and read the prayer. It was up to you if you wanted to read it, and it was up to you if you wanted to participate in the prayer itself. A group of organizations joined forces to challenge this prayer, claiming that it violated the Establishment Clause. New York Court of Appeals rejected their arguments. Now, this did go to the Supreme Court. The state cannot hold prayers in public schools, even if participation is not required and the prayer is not tied to a particular religion. The court held that respondents' decisions to use its school system to facilitate the recitation of an official prayer violated the Establishment Clause. Specifically, the policy breached the constitutional wall of separation between church and state. Okay, so the court ruled that the constitutional prohibition of laws establishing religion meant that the government had no business drafting formal prayers or any segment of the population to repeat in a government-sponsored religious program. So in this case, we see the end of school prayer. So this is seen as an incredibly controversial case at the time. Many saw it as a ruling against religion in our country, and there will be several other cases that will follow, all of them being shot down. So here you can see the headline where the Supreme Court outlaws school prayers in the court system. Now, that leads us to a very complicated case called the Public Education versus Nyquist, sometimes called the Lemon case. So, New York once again. In sections 1 through 5 of Chapter 414 of the New York's Education and Tax Laws, they had established some particular laws that individuals believed violated the Establishment Clause of the First Amendment. So as you look here into the facts, I have highlighted the main problems that people had. So we see tax laws that are created to aid programs for non-public elementary and secondary schools, so those parochial schools. This money and the tax laws included maintenance and repairs of schools. It allowed for tuition reimbursement, and it gave parents a tax break. So after the institution of these amendments, the Campaign for Public Education and Religious Liberty challenged these amendments in the United States District Court of the Southern District of New York, saying that this was violating the Establishment Clause. And the court held that sections 1 and 2 violated the clause, but not sections 3, 4, and 5. So here we see the Supreme Court trying to come together with, well, obviously this is very complicated. How do we decide what violates and what does not? And so we come up with what's called the Lemon test. So as you look at this chart, I want you to see across the top, I have what is the law doing, okay? And this is what the law is from that actual document. And then the Lemon test said that the law has to have a secular purpose. Secular, of course, meaning non-religious. It needs to have a neutral effect, meaning it doesn't favor one religion over another. And it needs to avoid excessive entanglements. So if we look at this court case, and we look at the first part, money for repairs of the building, is this a secular purpose? Well, yes, it does pass this test because this is about safety of buildings. So it doesn't matter, the public schools need to keep safe buildings and the private schools need to keep safe buildings. But when we look at the next column, it fails the neutral effect because there is no restriction on how the money is being used to repair what parts of the building. So the money could be used by the parochial private school to, fix the chapel, to update the interior of the church or the altar. It doesn't say it has to be used for classrooms. So this means that it fails. It doesn't have that neutral effect. It could easily be used for religious purposes. And because it fails here, we don't have to worry about excessive entanglement. Now, if we go over here, the money for schools, this, of course, passes because it prevents an overburdening of public schools. The reason that they're doing this is that the public schools are too crowded. It is of complete secular purpose. It is just about making sure that everyone is getting a better education. However, it fails on the neutral effect because the money goes to the schools and directly aids instruction. And it's not saying that the money can only go to the instruction of English or math or science. It obviously could go to the instruction of religion. Now, looking at the tax rebate that the parents would get, of course, that passes because it's the same as above. It's not for a religious purpose. It's secular in nature. However, it fails for the neutral effect because the schools benefit, not the child. The child isn't benefiting because the deduction requires that the parents pay tuition. So in this case, the parents are paying tuition to the church, which is paying, for the school for the religious school to have their education, and they're getting a tax rebate. And the parents who are paying taxes for their kids to go to the public school are not going to get that same. So this is called the Lemon Test, and this is what is going to be used from this point on in the examination of the Establishment Clause, is deciding whether or not a law is secular in purpose, neutral in effect, and avoiding excessive entanglements. All right, that is it for this portion of the Bill of Rights.